Get ready for the dictation in 3, 2, 1, start. It can be stated that the concept of public policy connotes some matter which concerns public good and the public interest. What is for public good or in public interest, or what would be injurious or harmful to the public good or public interest has varied from time to time. Stop. However, the award, which is on the face of it patently in violation of statutory provisions, cannot be said to be in public interest. Stop. Such award, judgment, decision is likely to adversely affect the administration of justice. Stop. Hence, in our view, in addition to narrow meaning given to the term public policy in Renu Sagar case, it is required to be held that the award could be set aside if it is patently illegal. Stop. Illegality must go to the root of the matter, and if the illegality is of trivial nature, it cannot be held that award is against the public policy. Stop. Award could also be set aside if it is so unfair and unreasonable that it shocks the conscience of the court. Stop. Such award is opposed to public policy and is required to be adjudged void. Stop para. In a letter judgment in the matter of Associate Builder Supra, Supreme Court, while reiterating the principles laid down in Saw Pipes Supra, issued a word of caution in applying all the heads, subheads of public policy test and held a good working test of perversity is contained in two judgments. Stop. In Excise and Taxation Officer cum Assessing Authority versus Gopinath and Sons, it was held, it is no doubt true that if a finding of fact is arrived at by ignoring or excluding relevant material, or by taking into consideration irrelevant material, or if the finding so outrageously defies logic as to suffer from the vice of irrationality, incurring the blame of being perverse, then the finding is rendered infirm in law. Stop para. A broad distinction has therefore to be maintained between the decisions which are perverse and those which are not. Stop. If a decision is arrived at on no evidence, or evidence which is thoroughly unreliable and no reasonable person would act upon it, the order would be perverse. Stop. But if there is some evidence on record which is acceptable and which could be relied upon, howsoever compendious it may be, the conclusions would not be treated as perverse and the finding would not be interfered with. Stop para. It must clearly be understood that when a court is applying the public policy test to an arbitration award, it does not act as a court of appeal, and consequently errors of fact cannot be corrected. Stop. A possible view by the arbitrator on facts has necessarily to pass muster, as the arbitrator is the ultimate master of the quantity and quality of evidence to be relied upon when he delivers his arbitral award. Stop. Thus, an award based on little evidence or on evidence which does not measure up in quality to a trained legal mind would not be held to be invalid on this score. Stop. Once it is found that the arbitrator's approach is not arbitrary or capricious, then he is the last word on facts. Stop para. A court does not sit in appeal over the award of an arbitral tribunal by reassessing or reappreciating the evidence. Stop. An award can be challenged only under the grounds mentioned in section 34(2) of the Act. Stop. The arbitral tribunal has examined the facts and held that both the second respondent and the appellant are liable. Stop. The case as put forward by the first respondent has been accepted. Stop. Even the minority view was to the materials available on record. Stop. Thank you.